Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. In this video, I want to talk to you about the case of Garrity versus New Jersey and compelled statements. Garrity versus New Jersey is a U.S. Supreme Court case that arose out of an investigation in New Jersey. The New Jersey police officers were allegedly involved in a ticket fixing scam, and the Attorney General's office decided to conduct an investigation. When the AG's investigators contacted the New Jersey police officers to give statements, many of the officers invoked their Fifth Amendment rights. And so the Attorney General's office contacted their police chief, and their police chief told the officers that they have a choice. They can either waive their Fifth Amendment rights and give statements to investigators, or they may remain silent. But if they do, they'd have to find a new job. And so many of the officers decided to give statements. They incriminated themselves, and at trial they were convicted. The case made its way all the way up to the U.S. Supreme Court. And the U.S. Supreme Court said that officers have Fifth Amendment rights just like any other citizen. And just because they're police officers or public employees, they don't have a watered-down version of constitutional rights. So the court found that the officers' statements were coerced and involuntary. Therefore, the statements were inadmissible against the officers, and the convictions were thrown out. And so as a result, there are a long line of cases, and the U.S. Supreme Court has been consistent that if an employer is going to compel an employee to give a statement as a condition of their employment, and their failure to provide that statement may result in discipline or termination, the statement is coerced, and the statement cannot be used against the public employee or officer in a criminal case. So that is the reason why we're always looking to protect your rights and make sure that you're compelled to give these statements. If you give a Garrity protected statement, if you're ordered by your supervisor to give a statement under the threat of insubordination, then that statement cannot be used against you in a criminal case. In addition, derivative evidence can't be used against you in a criminal case. A classic example is a case that occurred during the Reagan administration. This was a broad investigation into the Iran-Contra scandal. And in that case, Colonel Oliver North was compelled to give testimony before Senate concerning his knowledge about arms trades. His interview, his testimony was televised live throughout the United States. Same thing with Admiral Poindexter. And at the conclusion of their testimony, Colonel North and Admiral Poindexter were indicted by a grand jury. When their attorneys got involved, they protested the grand jury indictment, and they said that all of the evidence must have come from their testimony. And so the prosecution was required to prove by a preponderance of evidence that each and every piece of evidence came from an independent source and not from their testimony. And obviously the prosecution couldn't do that, and so Colonel North and Admiral Poindexter's convictions were thrown out. So the takeaway is that if the department compels you to testify or give a statement under the threat of insubordination and termination, then that statement cannot be used against you in a criminal case, nor can they use that statement to gather evidence against you in a criminal case. Garrity versus New Jersey is an important case, important rights for public employees, and important for you as officers of the Las Vegas Metropolitan Police Department. As always, please feel free to access all of these videos at LVPPA Metro on YouTube, or contact me at droger@lvppa.com. I'm always happy to answer your questions and perhaps provide video segments concerning important legal issues that are important to you. Thank you.